Good day everyone, I am Karil May Inasyon, and today I am joined by my team members, Miguel Ivan Balmes and Trixie Allen Santillan. So we are pleased to present to you the Chapter 4, Extinguishment of Obligations, and our topic covers the Section 1, the payment or performance, under the legal framework of obligations and contract. Extinguishment of obligations. So, understanding this is very important because obligations represent the foundational duties and responsibilities in business transactions, such as paying debts, delivering goods, or providing services. So, in the broader context of methods of research in business, this chapter is very important because it defines the legal endpoints of obligations. So, it clarifies when a business relationship or contract is considered fulfilled or terminated. So, knowing how and when obligation is extinguished helps the businesses or the companies to manage their contracts effectively. So, it minimizes the disputes and it ensures the compliance with the legal standards. So, the topic payment or performance under the Section 1 details the most common and straightforward way to extinguish obligations. So, it is by completing what is owed, like paying money, delivering goods, or performing services. So, this section establishes a clear standard for fulfillment and serves as a starting point for the exploring other ways of obligations that can end in business context. Article 1231 of the Civil Code of the Philippines, which is the causes of extinguishment of obligations. So we have here the payment or performance. So this means that the debtor fulfills the obligation either by delivering the exact thing or completing the required service. The next one is the loss of the thing due. So if the specific thing that is the subject of the obligation is lost or destroyed without any fault on the part of the debtor, and before the debtor has delayed in fulfilling the obligation is extinguished. However, if the debtor caused the loss or is in delay, the obligation persists. The next one is the consignation or remission. So, the creditor may forgive or remit the debt. So, this is a voluntary and gratuitous abandonment of the right to demand payment by the creditor. The next one is the confusion or merger of rights. So this happens when the roles of creditor and debtor are united in one person. And the next one is compensation. So this is when two parties owe each other debts and those debts are offset against each other. So this extinguishes the obligations up to the amount of the smaller debt. And the last one is the novation, which happens when a new obligation replaces an old one, extinguishing the original duty. As you can see on the screen, we have the obligation, which is the starting point. So this is when a person has a duty to do or to give something under the law or a contract. And we have the causes of extinguishment, like I said, payment or performance, so the debtor fulfills obligation. We have the loss of the thing due, consignation or remission. We have the confusion or merger. We have the compensation, and lastly, the novation. So once that any of these causes happens, the obligation is legally terminated or extinguished. So the debtor is released and then the creditor can no longer demand performance from the debtor. So here we have the Section 1, payment or performance. Article 1232, definition of payment. So payment is the delivery of money or performance of obligation in any form. So normally, people would think that payment is as simple as handing over money. But legally, payment means fulfilling the obligation in any manner agreed upon, not just by paying money. So this can mean delivering a specific item or performing a service as required by the obligation. So for example, if the obligation is to deliver a particular car, payment means actually delivering the car itself, not money or something else. So if the obligation is to repair a computer, payment means performing the repair and not just giving money. Article 1233, when debt is considered paid. So this article emphasizes the principle that a debt or obligation is only considered discharged or extinguished when the payment has been made completely and exactly as required. So this means that if the obligation is to deliver a specific item or provide a service, the debtor must complete the whole obligation without leaving parts undone. So partial payments or incomplete performance, even if accepted temporarily, does not extinguish the debt. For example, delivering only half of the goods ordered or performing only part of a service does not release the debtor from the obligation. And we have here the two important legal concepts. Here are integrity of prestation and identity of prestation. So integrity means the delivery or service must be whole and total, while identity means that it must be precisely the thing or service that was agreed upon and not something else. So this guarantees that the creditor receives exactly what was promised and the debtor cannot evade obligations through partial or improper fulfillment. Article 1234, Substantial Performance in Good Faith. So, good faith means genuinely intending to fulfill an obligation fairly and honestly without any plan to deceive or take unfair advantage. And it reflects trustworthiness in believing that one's actions, claims, or performance are lawful and right. So, this article actually serves as an exception to the rule of Article 1233 that requires complete payment or performance to extinguish an obligation. So it recognizes that sometimes, despite honest and sincere efforts in good faith, the obligor may not fully complete every detail of an obligation. And this law requires two requisites for this article to apply. So first, we have the substantial performance, meaning that the important or essential parts of the obligation have been completed and that the obligor acts in good faith with genuine intent to comply. So under these conditions, the obligor can recover or claim as if there were strict and complete fulfillment of the obligation. However, the recovery is adjusted by deducting any damages the obligee suffered because of the incomplete performance. So this condition or this rule balances fairness by compensating the obligor for what was done while protecting the rights of the obligee for any losses caused by the imperfection. So an example of this is a contractor built the main parts of the house but left minor finishing incomplete due to unforeseen circumstances. So the contractor acted in good faith and can claim payment minus damages for the unfinished parts. And another example is that if Maria sewed 45 out of 50 uniforms on time but was delayed on the last 5 due to material issues, she may still receive the payment for the 45 less deductions for the delayed items. Article 1235, Waiver of Incomplete or Irregular Performance. So this article deals with situations where the obligee accepts a performance that is incomplete or irregular. So this means that when the person who is supposed to receive something knows that what they are going to receive is not fully complete or perfect, but still they accept it anyways without any complaint or objection. So there are two important conditions here. First is the obligee must have the knowledge that the performance is incomplete or irregular, and second, they must accept it without protesting. So when these conditions are met, the law considers the obligation as fully terminated or performed, meaning extinguished. Tapos na. So this means that the obligee cannot later demand the missing part or require that the defect be corrected. So this legal concept is actually called estoppel. So it means that it stops the obligee from changing their mind and making another claim regarding the incomplete performance. So, for example, if someone sells a car but forgets to include the tire jack and the buyer accepts the car knowing this but does not complain, the seller's obligation is deemed fully fulfilled. However, it's important to note that if the obligee objects or protests at the time of the incomplete performance, then the obligation is not extinguished and the obligee can still demand full compliance with the obligation. Article 1236, Payment by Third Person. So this article deals with payments or performances made by third parties who are not the debtor. So the creditor is usually not required to accept payment from someone who has no interest in the obligation unless the parties agreed otherwise. So if a third party pays for the debtor, they have the right to demand the amount paid from the debtor. However, if the third party pays without the debtor's knowledge or approval, they can only recover up to the benefit that the debtor actually gained from the payment. So there are exceptions when the creditor must accept payment from a third party, such as when the third person is the debtor themselves, when there is a prior agreement allowing such payment, or when the third party has a legal interest in the obligation like a guarantor. So this article actually protects the rights of the debtors while also allowing third parties a way to settle debts and be reimbursed. Article 1237, payment without the debtor's knowledge. So this actually protects the debtor's rights when a third person makes payment without the debtor's knowledge or against their will. In such cases, the third party who pays cannot force the creditor to recognize them as the new party entitled to the debtor's rights, such as those arising from mortgages or guarantees or penalties involving the original debtor. So this means that the third party cannot step into the debtor's shoes regarding legal claims against the debtor's assets or enforce guarantees just because they made the payment. So this article essentially prevents unauthorized payers from acquiring rights they were not entitled to, thereby safeguarding the debtor's interest. So for example, supposedly Maria owes Juan money. Without Maria knowing or agreeing, Pedro pays Juan on Maria's behalf. So Pedro cannot claim Juan's right against Maria, like claiming Maria's house or as mortgage or any penalties Maria owes Juan. So Pedro actually just paid the debt but does not get the Maria's legal rights or protection. This means that Pedro cannot step into Maria's shoes to enforce guarantees or mortgages from Juan since he paid without Maria's knowledge or Maria's consent. So this article protects Maria from losing her rights just because Pedro made payment without her knowledge. And this example shows how the law stops any third parties from gaining debtors' rights by paying without approval or keeping the debtor's interest safe. Article 1238, donation by third person. So this article stipulates that when a third person pays for another without intending to get reimbursed, then the payment is considered as a donation or as a gift. And for this donation to be valid against the debtor must consent to it. However, if the creditor accepts the payment is valid in the eyes of the creditor and the one who paid for it, even if the debtor did not give their consent to the donation. So this means that the obligation is considered extinguished from the creditor's perspective, but the debtor might still not consider the payment as a gift unless they agree. So for example, Miguel owes Trixie a 1,000 pesos, and I, without intending to be reimbursed or get reimbursed, pays Miguel's debt to Trixie as a gift, and Miguel accepted or give consent to me. So since I do not accept reimbursement, my payment is considered as the donation, and this donation requires Miguel's consent to be valid. So if Miguel consents, Miguel is not liable to me, and his obligation to Trixie is extinguished. And if Miguel does not consent, I may recover from Miguel since it is not a donation, but Miguel's debt to Trixie is still extinguished because Trixie accepted Miguel's payment. Article 1239, free disposal and capacity to alienate. So for better understanding, let me define first what free disposal means and what capacity to alienate means. So first, free disposal means that the person has full legal authority over the property or thing to use or dispose of without restrictions, such as claims or liens from third parties. For example, a car is subject to mortgage, cannot be freely disposed of until the mortgage is clear, while capacity to alienate is the legal competence of a person to transfer or to give ownership of a property. This means that the person has the legal ability to enter into contracts and dispose of the property or thing due. For instance, minors or persons under guardianship may lack this capacity. So in simple terms, free disposal ensures that there are no third-party claims restricting ownership, while capacity to alienate ensures the person doing the payment or transfer has the legal power to do so, and both are required to validate a payment or transfer under the law. This article states that an obligation to give, payment made by someone who lacks the free disposal or legal capacity to alienate the thing due is invalid. This means that if the payer does not have the ownership control or legal authority over the money or item being paid, then the creditor is not obliged to accept it. For example, if a minor or someone legally incapacitated tries to pay a debt without proper authority, then the payment may be rejected, and the creditor cannot be forced to accept such payment. However, an exception under Article 1427 provides that if a minor between 18 and 21 years old voluntarily pays a debt without parental consent, then the creditor does not have to return the sum if it was spent in good faith. So, this article ensures that payment must come from person with legal authority to dispose of the payment subject. Article 1240 establishes that the payment must be made directly to the creditor, who is the person in whose favor the obligation was created, or to their legal successor such as heir or assignee. Alternatively, payment can be made to someone expressly authorized by the creditor to receive it, like an agent. So, if payment is made to the wrong person without authorization, the obligation is not considered extinguished and the debtor may still be liable unless the creditor was negligent or the debtor was misled by a fraudulent third party while acting in good faith. So, for example, if a debtor pays someone who pretends to be the creditor without the debtor's knowledge or authorization, then the payment is invalid unless certain exception applies. Article 1241, Payment to incapacitated person. So this allows payment to be validly made to an incapacitated creditor if they kept the thing delivered or they benefited from the payment. And this protects situations where the creditor cannot manage their property. Additionally, payments to third parties are also valid when the creditor benefits from it. And proof of benefit is unnecessary in three cases. So first one, when the third person takes over the creditor's rights after the payment. The second one is when the creditor ratifies the payment. And the last one is when the creditor led the debtor to believe that the third party had the authority. So for example, A owes B 1,000 pesos. B is a minor under guardianship, which is incapacitated to manage property, and A pays 1,000 pesos to B. So if B keeps the money or benefits from it, payment is valid. However, if B loses the 700 pesos due to negligence or gambling, only 300 pesos is considered valid payment. Another example of payment to a third person is when A owes 10,000 pesos to B, and without B's knowledge, C collects the payment from A. So later on, B ratifies this payment. So the payment is valid even if made to a third person because B approved of it.
Article 1242, Payment to person in possession of credit. Payment made in good faith to any person in possession of the credit shall release the debtor. So if you pay someone who appears to be the rightful holder of the credit or the note, and you pay in good faith, your obligation is cleared even if that person later turns out not to be the real creditor. For example, if the debtor owes the creditor 10,000 pesos and there's the deceiver holding a promissory note, the debtor pays the deceiver believing that the deceiver is allowed to collect, even if the deceiver isn't the actual creditor. The debtor is already released from the debt because he paid honestly in good faith. Article 1243. When the court orders the creditor to hold off on collecting payment, say while case is still being heard or pending, and payment was made after the order, it will be considered as invalid or not valid. The debtor must wait until the case is resolved or order is lifted before paying. Example, a court tells the creditor not to collect from the debtor until the dispute is settled. If the debtor still pays the creditor, that payment doesn't count, then the debt still remains because the court orders was ignored. Now, let's proceed to special forms of payment. Article 1244. Exact things must be delivered. The debtor cannot force the creditor to accept a different thing, even if it's equal or has greater value. So when you make a promise, you have to give exactly what you agree to give. Even if you think you're offering something much better or has more value, the creditor has every right to say no or refuse. Think of it as if you are about to deliver an iPhone 15, but instead you showed up with a Samsung phone, which is much has higher value. So the creditor has every right to refuse. Article 1245, Dation and Payment. Sometimes you and the creditor can agree on a different form of payment, like property instead of cash. That's called Dation and Payment. But it only works if both creditor and debtor agrees and actually accept the terms. Because you're transferring ownership just like a sale. For example, if you owe someone 100,000 pesos and both sides agree, you can turn over your motorcycle worth the same amount instead of giving away money or cash. Article 1246, Medium Quality. When the deal is for a type of a thing that is not a specific item, the rule is fairness. Neither party can go to extremes. The debtor can't give the worst quality, and the creditor can't demand the best. Say you agreed to deliver 50 sacks of rice with no brand specified. So you're expected to give a rice of a decent average quality, not the cheapest or the worst that you can find. And same applies with the other side. They can't demand or expect a premium grade rice either. Article 1247, Expenses of Payment. Unless agreed otherwise, extra expenses to make payment are for the debtor's account. So any extra cost needed just to make the payment, unless both of you agreed otherwise, falls on the debtor. But if the matter goes in court, then court rules decide who will pay the legal cost. For instance, if you hire a courier or travel to settle the debt in the place stated, then those extra charges are for you to cover. Article 1248, No partial performance without agreement. You can't break up a debt into smaller payment unless the creditor allows it. Likewise, the creditor can't force you to pay in parts if you never agreed. Example, if you owe someone 20,000 pesos today, you can't just hand over 5,000 pesos and expect the rest to wait unless the creditor is fine with it and fine with the terms. Article 1249, Legal Tender. Payment has to be made in the right currency. In Philippine legal tender, such as coins or peso, checks and promissory notes are not considered as legal tender. So if creditor says no to them, then it's legal for them to demand cash or peso or coins. For example, if you offer them check but the creditor wants cash, it's perfectly legal for them to refuse the check. Article 1250, Extraordinary Inflation. If the value of the money changes due to extreme inflation or deflation, the amount you owe still depends or based on the value when you first made the promise, unless both of you agreed to adjust. Say you promised to pay 100,000 pesos 5 years ago, and the price has since doubled because of inflation. You still owe that person 100,000 pesos unless both sides agreed with the rules that if ever there is an inflation or deflation, there will be some adjustments. Article 1251, Place of Payment. So payment must happen where the contract says. So if there's no specific place stated, let's say for unique items, you pay where the item was when you made the deal. Then for something that is generic, payment is or should be at the debtor's home. And if the debtor moves and it costs more to settle the debt, then the debtor should shoulder the extra or additional expenses. For example, if the agreement is to deliver a specific car in your garage, and when you signed, that is where you should deliver the car unless both of you agreed to move it in a different location.
Subsection 1, Application of Payment. Application of payment. When a debtor owes several debts to one creditor, the debtor can choose which debt to pay. The requisites are there must be one debtor and one creditor. Second, there must be two or more debt. Third, the debt must be of the same kind. Fourth, the debt to which payment made by the debtor has been applied must be due. And lastly, the payment mode must not be sufficient to cover all the debt. Article 1252. If a debtor has several debts, he may choose which one to pay. For example, if I borrowed 5,000 in January and another 3,000 in March, and I now pay 3,000 pesos, I can say it's for the January loan. That's my right as a debtor. However, payment cannot be applied to a debt that is not yet due unless the creditor agree. For instance, if I owe 4,000 that's already due today and 10,000 due next month, and I pay 5,000 now, the 5,000 should first cover the 4,000 unless my creditor agrees to use it for the 10,000. Finally, once a receipt is issued showing where the payment was applied, that become final and binding. So if the receipt says 2,000 pesos payment was for the March debt, I cannot later claim it was meant for the January debt. In short, the debtor chooses which debt to pay but not a future one unless allowed, and the receipt is the final proof. Article 1253. According to Article 1253, payment cover interest first, then principal. When a debtor pays a debt that earns interest, the payment is first applied to the interest before it can reduce the principal. For example, if I owe 10,000 with 1,000 interest and I pay 1,000, that amount will cover only the interest. My principal remains 10,000 until I pay more. This prevents the debtor from avoiding the interest by applying payment directly to the principal. Next is Article 1254. If unclear payment goes to debt with heaviest burden, example, higher interest. Article 1254 applies when it's unclear where a payment should go, such as when a person owes several debts to the same creditor. If there's no agreement or specification, the law says the payment goes to the debt that carries the heaviest burden. For example, the one with higher interest or stricter term. So, if I owe one debt of 5,000 with 12% interest and another 5,000 with no interest, and I make a payment without saying which debt is for, the law will automatically apply it to the 5,000 with the 5,000 debt with interest because that's the heavier obligation. In short, the interest is always settled before principal, and its unclear payment is applied to the more burdensome debt. Next is subsection 2, payment by cession. Debtor who can pay all debts assign all his property to creditor for them to sell and pay themselves. There are some requisites. First, there must be two or more creditors. Second, the debtor must be partially insolvent. Third, the assignment must involve all the properties of the debtor. And last, the cession must be accepted by the creditor. Article 1255. Effect payment by cession. There is a situational in law where a debtor, instead paying in cash, assign or surrender all his property to his creditor. This gives the creditor the authority to sell the property and apply the proceeds to the debt. But it's important to remember that the creditor does not become the owner of the property. He is only authorized to sell it on behalf of the debtor. The debtor is released from his obligation only to the extent of the net proceeds of the sales. For example, if I owe 200,000 pesos and I turn over my car and motorcycle to my creditor, the creditor may sell them. If the sales earn 150,000, then that 150,000 will be applied to my debt, but I will still owe 50,000 pesos. On the other hand, if the sales earn 220,000, then my 200,000 debt is fully settled, and the extra 20,000 is returned to me as the debtor. In short, assignment of property is not full payment by itself. It's only served as a means for the creditor to recover what is owed, and the debtor remains liable if the proceeds are not enough to cover the total debt. Dation in payment and cession distinguished. Dation in payment and cession are two ways of settling debt, but they differ in several important aspects. In dation in payment, there is only one creditors, while in cessions, there are several creditors involved. Dation does not require the debtor to be insolvent. It simply means the debtor is giving something other than money, like property, as payment. For example, if I owe my creditor 100,000 pesos and I give him my car worth the same amount, the ownership of the car transferred to the creditor and the debt is extinguished. On the other hand, in cession, the debtor is only insolvent and cannot pay to several creditors. The creditors do not become owner of the property. Instead, they only have the right to sell it and divide the proceeds among themselves proportionately. For instance, if I owe 3 creditors in total of 500,000, but my assets are only worth 300,000, I can assign my property to them. They sell it, and each creditor is paid a share from the 300,000, but I am still liable for any unpaid balance. Finally, dation is considered as an novation under Article 1291 because the original obligation is replaced by the delivery of things given, while cession is not considered novation since the obligations continue if the proceeds are insufficient. In short, dation is like direct barter of property for debt with one creditor, while cession is an insolvency remedy where many creditors share whatever assets the debtor has. Subsection 3. Tender of payment and consignation. Tender of payment, the debtor offers to pay the creditor the amount due unconditionally and in full. It must be an actual offer of payment, not just an intention. Consignation, when the creditor refuses to accept payments without just cause, is absence, incapacitated, or multiple claimants exist, the debtor may deposit the payment with the court to be released from the obligation. Requisites of a valid consignation. In order that the debtor may be released from his obligation by the consignation of the things or sum due, the following requisites must be observed. First, existence of valid debt which is due. Second, valid prior payment by the debtor and refusal without justifiable reason by the creditor to accept. Third, previous notice of consignation to person interested in the fulfillment of the obligation. Fourth, consignation of the things or sum due. And lastly, subsequent notice of consignation made to the interested parties. Article 1257 to 1259. Consignation is legal process where a debtor deposits the amount owed with the court when the creditor unjustified refuses to accept the payment, or when payment cannot be made directly. For consignation to be valid, the debtor must first notify the creditor and all interested party that payment will be made through consignation. Then, the amount is deposited with judicial authority which oversees the process and ensure all proper notices are given. If the consignation is properly done, the creditor cannot refuse it and the cost of consignation are charged to the creditor. For example, if I owe 50,000 pesos but my creditor refuses to accept my payment, I must first notify him, then deposit the 50,000 pesos with the court. Once the court accepts it, my debt is considered paid, and my creditor will bear the expenses of the consignation since it was his refusal that forced me into that process. In short, consignation protects the debtor from being unfairly penalized when a creditor refuses payment. Next is Article 1260-1261. In consignation, the debtor deposits payment with the court when the creditor refuses to accept it. But an important rule is that the debtor can still withdraw the deposit as long as the creditor has not yet accepted it or the court has not yet approved the consignation. If the debtor withdraw, the obligation remains as if consignation never happened. However, if the creditor authorized the withdrawal, the creditor loses any reference or priority rights over the debt. Also, if there are co-debtor or guarantors, they are released from liability once the withdrawal is authorized. Since the creditor effectively waived his right. For example, if I owe 100,000 pesos and deposit it in court because my creditor refused payment, I may still pull it out before the court confirms it. But if my creditor tells me go ahead and withdraw it, he cannot later claim preference over that debt. And my guarantor who promised to pay if I fail is also released. In short, the debtor's right to withdraw protects him, but if the creditors allow the withdrawal, he loses certain rights and guarantees tied to the debt.
First question. Why is the concept of extinguishment of obligation important in Chapter 4, Section 1 of the Civil Code? Extinguishment of obligation is important because it tells when a debt or duty officially ends. It protects the debtor from paying twice and assures that the creditor payment has been fulfilled. It gives clear rules like payment cancellation so both sides know the obligation was truly fulfilled or finished.
Question 2. What is the most important lesson from Article 1231 to 1261 on extinguishment of obligation? The most important lesson is that obligation can end in several lawful ways, not just through payment. This include loss of the things due, remissions, merger of rights, compensation, novation, cession, and consignation. This flexibility shows that the law balances the right of creditors and debtors, providing fair solution for different situations that arise in contracts and obligations.
Question number 3. How did AI assist your group? What challenges did you face? And how did you overcome them? So, our group used several AI tools to enhance our presentation, but we primarily utilize the use of ChatGPT and Perplexity AI to gather contents for our slide and of course to clarify some legal concepts that we do not quite understand. So for the visual presentation in our Canva, we especially use Gemini AI as an image generator to create custom visuals that match the template that we use. And I guess one of the biggest challenges was figuring out how to give the AI tools, especially Gemini AI, the right prompts. So sometimes it didn't quite get what we wanted, so we had to tweak our instructions many times to get the images that really match what we were talking about in our slides. So it took some trial and error before we eventually got pretty good results. And importantly, we made sure naman that the information provided by the AI match our assigned textbooks and some sources. So we cross-check all the AI-generated contents and references against our academic materials. So in this way, we made sure that the info was accurate and also reliable. So we weren't just blindly trusting AI this time. So we had to actively understand also and edit and also add our own ideas to make everything clear and correct. So in this way, we overcome the challenges of using AI. And that concludes our presentation. So thank you for your time and attention. We hope that this discussion has been insightful and meaningful for everyone. Have a great day.